Hey guys, hello, good people. Hello, good people. Hold on a second. Hey. Hello, folks. How you guys doing? Oh, somebody, it's 259 pages, but it's not all 259 pages from Steel. It's only 13 pages. Only 13 pages. I'm just going to wait a little bit more to get some folks up in here. Guys, do me a favor, hit the like button. Hit the like button, please. Hey, good energy. Haven't seen you in a while. Hello, everybody that's coming in. I just happened to see good energy, my Brooklyn Red Hook partner. Brooklyn Knights. Brooklyn Knights in the house here.
Hey.
Hello, everybody. We're back. We're back, part 2. And you see the title, Steel. Watch out now. Steel with the steel. Okay, thank you, Hippie. All right. So I've been running around. I came back in the house and my mom's downstairs cooking. So I said, let me go ahead on and bring this to you guys. This motion came in, this response to the state came in at 5:30, and I got the document, and my reader, 2 minds and 1 mic, is back up here with us, and she's giving up her service. She's been waiting on me. She's like, girl, where you been? She fell asleep, took a nap and all. But here we go, y'all. Let's go ahead and get started. She has 13 pages to read, and I'm gonna go ahead and put it up on this screen here. Still came with it, y'all. Still came in with it. He came in with it, y'all. He addressed everything. All the stuff that he needs to address, he addressed it. So here we go. I'm gonna put it up. All righty, here we go. I'm not wasting any more of your time, but here it is right here. And let's rock and roll.
All right. State of Georgia versus Jeffrey Williams. Mr. Williams' response to state's motion to restrict extrajudicial statements filed on July 23rd, 2024. Number 2, motion to adopt motion for fair and constitutional trial on behalf of Mr. Stilwell, as well as Diamante Kendrick's motion for mistrial, both filed on or about July 23rd. And 3, notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge, filed on or about July 23rd, 2024. So he said, I'm going to address everything at once. Comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby files this response to state's motion to restrict extrajudicial statements filed on July 23rd, 2024. Motion to adopt motion for fair and constitutional trial on behalf of Mr. Stilwell, as well as Diamante Kendrick's motion for mistrial, both filed on or about July 23rd, 2024. 3, notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge, filed on or about July 23rd, 2024 in the above reference case. In support of the response, Mr. Williams shows as follows. Moment. Mr. Williams is innocent of all crimes in the above referenced indictment. 1, response to state's motion to restrict extrajudicial statements. Footnote 1, as previously announced in open court on the record, undersigned counsel hereby rejects and objects to any proffer made by lawyer Love and or lawyer Hilton. See State vs. Shangleheen, 370 Georgia 202-896. Wait a minute. What is happening?
It jumped.
Yeah, it's jumping right out. 1 second. Okay.
I've heard that people saying that it does that.
Yeah, it's doing it really bad. Hold on 1 second. Okay. Bear with me, guys. On or about July 23rd, 2024, the state filed a motion to restrict extraditional statements. Mr. Williams' counsel statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. In contrast, the state failed to alert this honorable court that before and during jury selection, when the potential jurors were not fully charged to avoid all media reports concerning this indictment, the following occurred. 1, Fox 5 press conference with Fulton County District Attorney Bonnie Willis, dated May 10th, 2022. And the link is there. District Attorney Willis speaks from 1121 to 1907, from 2037 to 2113, and again from 2219 to 2418, including the following. In reference to District Attorney Willis, claiming her priority is to prosecute gangs, and there's a reason for that. They are committing conservatively 75 to 80% of all of the violent crimes we are seeing in our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, then you are going to become a target and a focus of this district attorney's office. And we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment and hopefully to bring justice to a lot. Come on, go down. What's happening? We are missing a page.
Yeah, just go down.
Hold on 1 second.
Just go down.
Yep, I am. Hold on 1 second. Okay. Of the community who we are victimized through the course you'll see in this indictment. But more importantly, the most important thing we are here to do is keep this community safe. And we believe removing these 28 defendants will keep Fulton County safer. Reporter, these are some serious, significant charges. I would imagine you're going to seek some pretty serious sentencing here. I know it's early, but you can talk a little bit about the sentences. They Where are we at?
Are you having, where do you
Okay.
have? Oh.
Okay, got it. The problem is that it is jumping on its own, trying to go down to the motion. So I'm just separating it so we don't have this issue with all 13 pages. This one is pretty bad with that. Okay. Wow. Okay. Sorry, guys. Sorry, guys. Okay.
Are you doing it from a tablet?
No, I'm on my laptop, but it keeps trying to go, as the others were stating it, jumping around. When you stay on that page, it does kick you off, but I just got back to it.
Sometimes you have to download it and it won't jump, but you didn't have time.
Okay. Nope, I just did. So just give me one. I'm gonna reread that part so they don't. Okay. It all downloaded. All right, guys, here we go. We're back on. I'm gonna just go over that part for you guys just because it broke up.
A, right?
Mm-hmm. In reference to District Attorney Willis claiming her priority is to prosecute gangs, and there is a reason for that. They are committing conservatively 75 to 80% of all the violent crimes we are seeing in our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, then you are going to become a target and a focus of this district attorney's office. And we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who were victimized through the course you'll see in this indictment. But more importantly, the most important thing we are here to do is keep this community safe. And we believe removing these 28 defendants will keep Fulton County safer. B, reporter. These are some serious, significant charges. I would imagine you're going to seek some pretty serious sentencing here. I know it's early, but can you talk a little bit about the sentences they may be facing? District Attorney Willis will ask on the different charges for the maximum penalty. There's obviously many people that are looking at life under this indictment. You're absolutely right. These are serious times. They're serious allegations, and in my opinion, that violence in our community deserves maximum penalties. C, reporter. How big is this gang? Is that a good portion of the gang here operating in Atlanta? And how long were you investigating them? District Attorney Willis. If you look at the indictment, the crimes that are alleged within go all the way back from 2012 to 2022. I wouldn't say that it contains every active crime that YSL committed. It is a significant gang that operates here in Atlanta, Georgia. Not every member became a defendant within this indictment, but certainly a significant amount did, and certainly some of the leadership, which is what's most important. D, District Attorney Willis notes that this investigation indictment has been a long effort of the District Attorney's Office and reports on her conversation with Mr. Thomas' mother, a deceased in the case, citing her hopes to obtain her justice. Below is a link to episode 3 of the podcast King Slime. The prosecution of YoungThug and YSL released in August 2023 during voir dire and prior to jury selection. The podcast has then stopped recording episodes, but was hosted by music journalist Christina Lee and the honorable reporter George Chidi. Chidi. District Attorney Willis made it clear that she cannot provide specifics of the case, however, shares the following. District Attorney Willis segment from 818 to 1348, 1724 to 1926, 2015 to 2140, 2516 to 2710, 3746 to 3840, and 5017 to 5120. And that is on Spotify. 1737, District Attorney Willis. I remember when we first took office, we're screaming from the top of the top hills that there's a gang problem. And people were really actually kind of treating us like we were crazy, right? There's a gang problem in LA. There's a gang problem in Chicago. But they did not want to admit that there was a gang problem right here in Atlanta. But we kept talking about facts I knew to be true because I knew crime waves. I knew that one important person got killed and we got a war for several years. 2015, reporter Chidi brings up 75 to 80% statistic district. Attorney Willis claimed at her initial press conference referenced above, District Attorney Willis. I think the stats that we're depending on are actually low. What we are talking about when we tell those numbers are self-identifying people that have already gone into the penal system. And they're identifying actually as gangs, or we're finding their mail or their phone. So we're not hitting a lot of people. The one thing that is unique about this group, it really doesn't count if you're in a gang, if you don't claim it, right? So you'll find that even in police interviews where they'll tell you what set they're from, they're proud to declare it, or they'll have a tattoo on that says it, or through emojis, or through direct language on social media. So we're just talking about those that we know. 3805, District Attorney Willis. I hope that you know, for gang members, I am hated and feared because I'm not going to apologize for bringing gang warrants or educating the police on how to bring gang warrants, and for prosecuting people that decide to get into that life. 5032, District Attorney Willis. It is so interesting you talk about snitching because everybody hard, right? Till they sitting in that seat. I've been doing, I already said, a very, very long time. I personally have tried, over 100 homicides, prosecuted hundreds of them because of pleas and other.
Sorry about that. What number are you up to? Because my mother had something going on. I had to go downstairs to help her.
I'm on 5, at the end of page 5.
Okay, thank you.
Section D. Ready? Literally all I did for a very, very long time. When people get to sitting in that seat, more often than not, they snitching because the choice is life, or you can tell what someone else did and what their involvement was. So what's really cool to say on social media, but when it's you sitting in there and your mama and your woman, you got a baby on the way, you got all these other responsibilities as a man you need to tend to. You got to make grown folk decisions for you and your family. And so often the decision is, I'm going to tell you the truth and wrap this up for me. Lawyer Love's motion to restrict extrajudicial statements must be rejected. It is rich, audacious, and hypercritical that the state seeks to critique as unethical the single statement by Mr. Williams' counsel, which contains accurate factual assertions. As an overreaching principle, Rule of Professional Responsibility 3.6, Comment 1, makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, when they mandated that those accused of crimes are guaranteed the right to a public and speedy trial. There are vital social interests served by the free dissemination of information about events having legal consequences and about legal proceedings themselves. The public has a right to know about threats to its safety and measures aimed at assuring its security. It also has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. Furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. Rules of Professional Responsibility 3.6, Comment 1. Moreover, comments 5A and 5B delineate certain subjects about which lawyers could speak, which are more likely to have material prejudicial effect on a proceeding, and those subject areas are more likely not to have no material prejudicial effect on a proceeding. In a criminal case, comments which are most likely have a material prejudicial effect on a proceeding include subjects relating to 1, the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, or the identity of a witness, or the expected testimony of a party or witness. 2, the possibility of a plea of guilty to the offense or the existence or contents of any confession, admission, or statement given by defendant or suspect, or that person's refusal or failure to make a statement. What is more relevant to the issue at hand is the commentary relating to those subject areas more likely than not to have no material prejudicial effect on a proceeding. The subject areas include 1, information contained in a public record. 2, the scheduling or result of any step in litigation. Every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. Specifically, Mr. Williams has reportedly, in public filings as well, by and through his counsel in open court, maintained his innocence. Mr. Williams filed motions for speedy trial. The recused judge, Lawyer Love and Lawyer Hilton, have been accused of and found to have run afoul of their duties under the law. And Judge Glanville has been recused and disqualified from his role as trial judge based on motions brought by Mr. Williams. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel. The coverage is available to the public at the click of a link, even when not watched live, as recordings are maintained on www.youtube.com. Thus, the likelihood that Mr. Williams' counsel's repetition of information in the public and/or findings of the court could materially prejudice or hold on. 1 second. Okay. Court could materially prejudice an adjudicated proceeding and the matter is absurd. Moreover, the jurors in the case have been provided cautionary instructions and admonitions countless times, at least daily, over the 100+ days of trial, not to listen to anything related to this case. So unlike pretrial comments, which the state is guilty of making, there is no bias for Mr. Williams' counsel to believe that his statement will have a substantial likelihood of materially prejudicing or adjudicate proceeding. 2, adoption of Mr. Stillwell and Mr. Kendrick's motion for mistrial. Only if this honorable court court finds that Mr. Williams was goaded into moving for mistrial based upon prosecutorial and judicial misconduct, and thus retrial is barred. Mr. Williams has been forced to remain in custody while the recused judge and lawyers Love and Hilton violated Mr. Williams' right to a fair trial, fair tribunal, right to due process, right to confront witnesses, and the like, causing Mr. Williams to be goaded into moving for a mistrial, as demonstrated by few examples as follows. 1. Mr. Williams was denied his constitutional right under the Georgia Constitution and federal Constitution to be present at critical stages of his proceeding. See Exhibit A, transcript of ex parte hearing in chambers dated June 10, 2024, attached hereto. The recused judge meeting with sworn witness, Mr. Copeland, was a critical stage of the proceedings in which Mr. Williams and his counsel had, as a matter of law, the constitutional right to be present. See Scudder v. State. In the case at bar, the recused judge, lawyer Love, and lawyer Hilton unlawfully influenced Mr. Copeland to testify against Mr. Williams. See Exhibit A, specific transcript pages referenced in Exhibit B, joint affidavit of Brian Steele and the Honorable Keith Adams, attached hereto. Under the federal Constitution and Georgia Constitution, Mr. Williams was prejudiced by being wrongly excluded from this critical stage of the proceedings where Brady evidence, judicial misconduct, and prosecutorial misconduct was captured and intentionally concealed from Mr. Williams and his counsel. See footnote 4. 2. Lawyer Love and lawyer Hilton will be called as necessary witnesses in this trial by Mr. Williams, as material conversations with sworn witness Copeland are not captured on the transcript of the June 10, 2024 unlawful ex parte meeting. See, for example, Exhibit A, pages 22, lines 3 through 10, pages 40, lines 20 through 25 through page 41, line 1, as well as other matters wherein lawyer Love and lawyer Hilton must be examined as to other ex parte communications with the recused judge and concealed Brady Giglio evidence. The recused judge violated Mr. Williams' constitutional right to confront prosecutorial misconduct when lawyer Hilton introduced a known void, null, invalid, involuntary guilty plea before the jury. Specifically, lawyer Hilton elicited testimony from Detective Racy about an invalid, void, involuntary guilty plea, knowing that same does not exist under law to push the prosecution's invalid theme that Mr. Winfrey was protecting the supposed perpetrated gang members now on trial in the case at bar. The recused judge refused to permit undersigned counsel to confront Detective Racy and prove that lawyer Hilton was eliciting non-factual and knowing misleading testimony to the petite jury. This denied Mr. Williams his constitutional right to cross-examine witnesses, constitutional right to a fair trial, and constitutional right to a fair tribunal. See Exhibit C, Notice of Attorney Proffer, filed on July 1st, 2024, attached hereto. Lawyer Love has attempted to demonize counsel for Mr. Williams as well as other accused counsel in front of the jury. This appears to potentially be lawyer Love's standard practice. See Exhibit D, the appeal medical staff at notorious Atlanta jail let autistic teen waste away and die. Lawsuit says pages 6 through 7, attached hereto. Prosecutorial misconduct has been perpetrated by Lawyer Love from the inception of this case in order to goad Mr. Williams into moving for mistrial. See, for example, Exhibit E, motion for fair trial, filed on July 10, 2024, attached here too. The above few samples prove in which event in any wrongful conviction of Mr. Williams, there is a substantial likelihood of reversal by appellate court, including a court presiding at a motion for new trial. Therefore, the continued incarceration of Mr. Williams is punitive without legal justification. This past month and a half alone finds Mr. Williams helplessly trapped in a cell based upon the intentional misconduct of lawyers Love and Hilton and the recused judge. This delay in causing the Honorable Court to parachute into the case has infringed upon Mr. Williams' freedom. Respectfully, bond must be granted. This continued incarceration of Mr. Williams is unconscionable, as has much of this trial under the guiding hands of the recused judge and lawyers Love and Hilton. The prosecutors and recused judges' misconduct and trampling of Mr. Williams' constitutional rights has forced Mr. Williams to timely move for several mistrials after being goaded into the same. This trial is not fit for a kangaroo. Mr. Williams lawfully filed a statutory demand for speedy trial. See Exhibit F, demands for speedy trial, attached hereto. No reasonable person would argue that a speedy trial has been satisfied. For example, the recused judge ordered Mr. Williams to be held in custody without bond since May 9, 2022, while over 2,000 potential veneer panel members were mostly individually dired for hardship. There was no valid reason to summon over 2,000 potential jurors since the petite jury was selected from the first 511 jurors who were all summoned to the courthouse on January 4th, 2023. Undersigned counsel will be inquiring of the recused judge as to the reason that Mr. Williams had to endure suffering in custody, months of unnecessary individual jury hardship questioning. This unnecessary elongated process of jury selection was a waste of time and violated Mr. Williams' constitutional and statutory rights to a speedy trial. This continual waste of time has caused Mr. Williams to be wrongfully denied freedom and a fair, speedy, constitutionally sound trial. Mr. Williams has given reasons for bond to be granted. See renewed motion for bond filed on July 23rd, 2024. In order to be released from the unlivable, inhumane conditions of the county jail that he has wrongfully endured since May 9th, 2022, Mr. Williams had offered conditions of bond to include release with 24-hour surveillance by law enforcement. While Mr. Williams is not a significant risk of flight or a significant threat to others in the community and thus does not need law enforcement to surround him, he has, however, offered this extreme provision if this honorable court wishes to apply that condition. However, under all circumstances, a pre-verdict bond must now respectfully be granted. The past will never be forgotten, but Mr. Williams' improper detention and unlawful suffering must end. Furthermore, counts of this indictment fail to allege at least one essential element of the crime. Thus, there is a fatal variance and jeopardy has attached thus. This case has never been retried and should be dismissed at the time as a general demurrer can be filed at any time. See Exhibit G, plea and bar motion to dismiss, general demurrer attached hereto. The recused judge denied this timely filed plea and bar motion to dismiss General Demur then denied a certificate of immediate review, and thus the Honorable Court of Appeals of Georgia dismissed Mr. Williams' direct appeal for lack of jurisdiction. See Exhibit H, Court of Appeals of order dated January 19th, 2024. See Exhibit I, order denying Jeffrey Williams' plea and bar motion to dismiss General Demur attached hereto. Thus, the law of case doctrine does not apply, and Mr. Williams asked this honorable court to decide this General Demur issue so this case or counts thereof can lawfully end in stanter. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, ask this honorable court to grant the above requested relief. This 26th day of July 2024, respectfully submitted, Brian Steele and Keith Adams. You want me to get the footnotes?
Yes, I had to unmute myself. Yes.
Okay, let's go to footnote 1. Okay, I did 1. Let's go back to 2. Footnote 2, Mr. Williams adopts in full Mr. Kendrick's opposition to state's motion to restrict extrajudicial statements filed on February 26, 2024. Next footnote. Footnote 3, Mr. Williams does not join in Mr. Nichols' motion for mistrial without double jeopardy protection. Footnote 4, unlike the federal constitutional provision, the violation of the criminally accused rights to be present under Article 1, Section 1, paragraph of the Georgia Constitution is automatically cause for reversal of any conviction and sentence, regardless of any showing of prejudice. See Sampson v. State, Tavares v. State, Mayo v. State. Regardless, great prejudice has been caused by the recused judges, Lawyer Love and Lawyer Hilton misconduct, as a witness was influenced to testify against Mr. Williams. Brady evidence was hidden. The trust in the court is irreparable damage, and the like. Let's go to the next footnote. Okay, that footnote's gone, so we're on Exhibit A.
We don't need to, we can just.
Did you want to look at,
We did all of these already.
no, what he said was attached about ex partes?
No, we did all those ex partes. We don't need to do another one.
Okay.
We did all of those. Those are just repeated stuff from before.
Well, I didn't know there was a plural. It looks like he included maybe something that occurred.
June 10th.
Okay. That's it for that motion.
Yep, that's it. Let's see. Okay, that's all the exhibit because we had all the other exhibits from before, so we don't need to do another one of those exhibits. I was reading some of the messages. Hippie, I don't have your email. Hippie, I don't have an email. So send me your email. Okay, let's see. Let me see if anything else has come in yet, y'all. Just bear a minute with us. Last, got a notification. Hold on. I don't see anything else for the state, guys. I don't see anything else for the state.
Well, she should be reading this at the same time we are.
I don't see anything. Nope. The last thing was the 531. That's it. Nothing else.
I can't even believe that they put 75 to 80%, where those percentages can not be proved.
Okay, what I'm gonna do, guys, I'm gonna show the video that still reference with Fonnie. I can do that for you guys on those markers. Let's do that. I go back up. $11.21. Hold on. Are you ready? This is the press conference. That's my buddy right here. Look at him. You guys remember this press conference, right? You guys remember this press conference? All right, let's put my banner for copyright disclaimer. Copyright disclaimer under Section 107 of Copyright Act of 1976, allowances made use for fair use for the purpose of criticism, comment, news reporting, teaching, scholarship, and research.
Everyone's listening to you, so where you at? We all here. Everyone's here. Everyone say hi, Maria. Hi. Well, I did. You're live. The DA is listening to you right now. Maria, call me back. I don't want to lose the battery, but we're here. I'll see what I can see. Okay. All right. All right, leave 30 minutes. You get 30. All right, guys, give me a warning. Okay, guys, I'm back. Okay, very good. I tried to do that.
You got. I'm gonna move all the way till 6:11. 11 minutes because that's when they have it. 11 minutes. Okay, there we go.
We're ready. First of all, I want to say good afternoon to you all. Thank you all for coming out. Want to acknowledge the DA and Fulton County Sheriff. We're here today to speak on the arrest of Jeffrey Williams that in collaboration with Fulton County DA's office and the Fulton County Sheriff on yesterday. This collaboration is representative of the partnership of the Atlanta Police Department and the DA's office on our aggressiveness and going after gang members. The mayor, as well as the DA, gave a interview on last week expressing their concerns about what we were seeing in our city and how we would go after any offender. And at the direction of the DA taking the lead on us yesterday, making sure that we were able to get one of our top offenders off of the street. In partnership with them, utilizing our tactical teams, we were able to go out to the individual's location and arrest him without any significant consequences to him or any other parties at the house. And so with that, I'll turn it over to the DA.
Thank you, Chief Bryant. Today, I'm joined by the Atlanta Police Chief, Chief Rodney Bryant, as well as my sheriff and our sheriff, Sheriff Patrick Labatt. We are here today about a grand jury indictment that was returned that included not just Jeffrey Williams, which is of some notoriety and media attention, but about 28 defendants that operated within our community between the time period of 2012 and 2022. It is our allegation that they operated as a criminal street gang and commenced to do havoc in our community. That havoc includes crimes of violence, crimes of thefts, crimes involving drugs. I've made no secret about it, nor any apology that as the district attorney of Fulton County, my number one focus is targeting gangs. And there's a reason for that. They are committing conservatively 75 to 80% of all of the violent crime that we are seeing within our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, that you are going to become a target and a focus of this district attorney's office, and we are going to prosecute you to the fullest extent of the law. I agree with Chief Bryant. What you see yesterday and what you will see in the upcoming months and years is the result of a lot of hard work by both the Atlanta Police Department and this office. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who was victimized through the course you see in this indictment. But more importantly, the most important thing that we are here to do is to keep this community safe. And we believe removing these 28 defendants will keep Fulton County safer. Yes, sir.
The indictment's got YoungThug and a bunch of other rappers. There was one name I was actually expecting to see there that I didn't, and that's Jeff Harlow. Can you speak to that?
What I'll tell you is that as large as this indictment is, I told my team that let's not be sexy, now let's not overreach. Let's be conservative in our approach, which is always the approach that I take. And in taking that approach, 28 defendants were indicted, and they were indicted for the crimes that I believe were appropriate for this RICO indictment. And so I won't speak to any person that is not named.
These are serious, significant charges. I would imagine you're going to see some pretty serious sentencing here. I know it's early, but can you talk a little bit about the type of sentences they might be facing?
Well, we'll ask on the different charges for the maximum penalties, and there's obviously many people that are looking at life under this indictment. You're absolutely right. These are serious times. They're serious allegations, and it is my opinion that violence in our community deserves maximum penalties.
In a recent interview, you said in the coming weeks and months to expect indictments, RICO charges, gang charges. We see that with here. This is only focused on the YSL gang. At that time, you used plural indictments. Should we expect more indictments against singular gangs in the coming weeks and months? Is that what you were meaning with that quote?
Yeah, and if you're already aware, we dropped an indictment not that long ago against YFN. It is certainly a tool that I believe in, which is using RICO. I believe the reason that I believe in it as a tool is it allows juries and the communities to see the complete picture of a crime so they can truly be educated and have facts to weigh when they're making decisions. And so if you're asking, should you expect to see other RICO indictments against other street gang organizations? Absolutely.
Two questions specific to YSL. The 20-some people arrested here or named. How big is this gang? Is that a good portion of the gang you're operating in Atlanta? And how long were you investigating them?
If you look at the indictment, the crimes that are alleged within it go all the way back from 2012 to 2022. I wouldn't say that it contains every act of crime that YSL committed. It is a significant gang that operates here in Atlanta, Georgia, and not every member became a defendant within this indictment, but certainly a significant amount did, and certainly some of the leadership, which is what's most important. We're not going to just target the children that are running out at the direction of leaders and not target leaders.
Madam DA, how much?
Go ahead, Michael.
Sure. How much did social media, music play a role in bringing this indictment?
Social media is a wonderful tool for prosecutors in every indictment we bring nowadays.
And let's talk about, obviously, YSL. They're the territories that Cleveland Avenue is no secret. We've seen a ton of violence, innocent bystanders get hit. So you guys believe that by getting them off the streets, that people in that neighborhood who are living in fear can actually have some peace now?
I believe that people in that neighborhood and at every corner of Fulton County deserve to be safe, even if it is financially lower, socially, economically. You know, I don't think that part of the community should be left behind. Me and the mayor and the police chief have talked about the fact that Cleveland in our community is referred to as Bleveland, that it is somewhere where just violence occurs, where they're marking up territory, it's blood territory. It's horrible. And you're absolutely right. That community deserves to be safe. And we are hoping that this helps to keep them safe.
Let's talk about safety. We know these gang members are going to be housed or brought in at the same time. How are you and Sheriff Labatt working to keep them away from each other in the jail, especially with YS and Lucci being targeted as that came out recently?
Well, I won't step outside of my lane. I am the district attorney of Fulton County. I am not the sheriff. I have great confidence in the sheriff. He knew that this was coming as a law enforcement partner. And I believe that he is well prepared, but you'd have to speak to him to make sure that everyone within his facility is safe.
This indictment names a few, it's not just social media posts, but songs that have been released by YoungThug and others, where it's supposed to be the lyrics, evidence supporting the legal conspiracy. And I'd like you to speak to the First Amendment issues that obviously raises.
This issue's been ruled on by the courts. I knew that question was coming. I believe in the First Amendment. It's one of our most precious rights. However, the First Amendment does not protect people from prosecutors using it as evidence if it is such. In this case, we put it as overt and predicate acts within the RICO count because we believe that's exactly what it is.
Let's allow Sheriff Labatt to answer those questions.
I have one more from Ms. Willis. What's the last time you prosecuted a RICO case? Was that the APS case?
This office? No, since I've been here as the district attorney, I think we've indicted probably 4 or 5 RICOs at this point. So it's a tool I use.
First of all, good afternoon. I believe both Madam DA and Chief Bryant are really raising the level of consciousness in what we're doing within Fulton County, and certainly they deserve our appreciation. With respect to the specific question as to safety and so many people being brought in, we are housing them accordingly to include other facilities. So I encourage everyone to really download the Sheriff's app if you want to know specifically where individuals are, and you'll be accommodated accordingly.
Sheriff Levine. So like, as I've done through the indictment, there was an element of it where they were talking about Octavius Greer communicating with an inmate, where the inmate had a cell phone that was contraband. But it was clear from the indictment that you had been, or that all of you had been monitoring that conversation. Like, it leads me to ask a question you're probably not going to answer. Was that cell phone deliberately given to an inmate so that those conversations could be monitored?
So I did have an opportunity to read your editorial that you posted in the Buckhead blog or whatever it was from that perspective. And so you're right. I'm not going to answer that. So, appreciate it. We'll leave that to Madam DA.
Can you tell us of the 28 who were indicted, how many have been arrested, how many are large, how many are already in custody?
And I do not have that exact number. I can tell you approximately 10 were already in custody. I believe as of last night, we had arrested at least 3 as of last night. I expect to see more arrests today and in the upcoming weeks, but I'm realistic. It's probably going to take the next 2 weeks to get everyone in custody.
There's been some discrepancies about where Gunn is. Maybe this is better for the sheriff. Where he's being, is he in custody?
Short answer, Michael. He's not in custody.
I mean, has there been arrangements for him to surrender, or is he considered a fugitive right now?
Well, we're making arrangements as much as he had representatives call me last night directly. So we'll muddle through that piece and let you know. And again, download the Sheriff's app. Make sure.
Sheriff, one more question.
Yes, sir.
Have you had to take any special precautionary measures at the jail in light of high profile? I mean, you mentioned people getting housed differently, but just safety for your corrections officers. I mean, what kind of, are you able to reveal some of the things you've had to do in light of?
And that's a great question, and I appreciate you taking the time to come visit us a couple of weeks ago. To that extent, based on some of the things that we found, we've already begun new procedures. And so the opportunity for us to maintain safety is paramount. Thank you.
Follow up on Michael's question with the indictment and names being out there now. Are any of the individuals considered fugitives? Is there a worry that some of them are on the run now? Do they know that they're indicted?
In this business, I'm certain that there will be some people that won't volunteer to come into custody. There is no concern that somebody will escape being arrested.
One last question, I'm sorry. How significant was the arrest of Christian Eppinger with regard to the timeline of this indictment? Like, I have been looking at it where that arrest set off this 90-day clock. But I'm reasonably certain you were looking at YSL before all of this. Did that create a sort of a time situation where you wanted to get this done?
No, there was long ago a time sensitive importance or significance to this particular case. I was a prosecutor, as you know, for 16 years, 4 months, and 4 days in this office. The murder of Donovan Thomas in 2015 created violence like Atlanta has never seen. It was a goal of my predecessor and any person or prosecutor in this office to make sure that that family received justice, because everyone is entitled to justice. Was a commitment I made from the first day I walked into this office. Very shortly after me becoming the DA, I sat down with Mr. Thomas's mother and I made her a promise that her son was as valuable as any other person within our community, and that I would put resources on this case, and that I would do everything I could to make sure that her son had justice. And yesterday was a proud day for me.
Was there any connection between the killing of YoungThug's children's mother and this gang?
I don't believe any. Thank you.
All right, guys. All right. All right, that was the the press conference right after the arrest of Jeffrey Williams and 2 others, but you heard her say there was 10 that was already in custody. 10 that were already basically serving time. Okay, let's see. Hold on. There's something else I wanted to show you guys. Hold on. I have to go into my stash of videos. I have to go into my stash of video. Just 1 second. Are you there?
I'm here.
Okay. Trying to pull it up. There's something I need to pull up.
I was looking at these forced immunity lawsuits.
One second, people, good people. I just got to find something that I'm looking for.
While you're looking for that, do you know what type of immunity they granted?
Granted, who?
Woody, was it transactional immunity or derived immunity? Do you know which one?
I forgot the name of it. I forgot the name.
So there's actual lawsuits for forced immunity for violating Fifth Amendment.
When I'm trying to find something, y'all, just bear with me. All right, y'all. I had to show you guys the video when Bonnie Willis was Mondo's attorney, and I have that video. Hold on. All right, here. You guys see it?
I want to see this now. Let's okay. All right. Now, where's that cute baby? Baby. Yeah. How old is the baby? 7 months. She's 7 months. Have you seen the child? No. Stand right there. Do not move. Come up here. Okay. Thank you.
That's Bonnie right there.
Okay, you get one hug. Now, and while you're hugging that really, really cute child, remember that's a reason you want to be back in front of me. Because if you care about it, don't do stuff that gets you in front of folks like me. All right? Yes, she is. Okay, people back. Time's up. Well, good luck. I want to see you again on the streets, okay? All right. Now, where's that cute baby? Baby. Yeah.
Y'all see that, right? This is when she used that court with him. Y'all saw that? That be respectful towards the chat of others. Okay, have anything else dropped lately, guys? Have anything dropped? Why she's always looking rush. Just getting here. Did you read the new ex parte transcript? Okay, we got a response. Another response, y'all. You guys are ready? DA Love just filed a response. Just a second. Six p.m. this came through. Yeah, we got to see what she says about this one here. Hold on.
Still will respond by 9 o'clock.
No, this is her response to the defendants. Still will not have to respond. She's responding to his. Okay, I'm back. I'm back, guys. I'm back. Are you there, ma'am?
I am here.
All right, I had to get the what's the name? Hipster says
I don't see it in, I don't see it in the email though.
Hmm?
Oh, okay, there we go.
Hipster, did you email me?
I think Hipster wanted volunteer to read this one for you.
Yeah, but I asked her to send me her email. She hadn't sent me an email. I didn't get any emails from her. I'm waiting for the email.
Let me see if she dropped it in.
You gotta go to urgent care. Crazy, but I gotta go to urgent care. I'm sick. Oh my God, feel better. Feel better. Okay, go ahead and read it because I'm waiting for her email because I haven't gotten anything from her. Y'all, can y'all please I volunteered by Miss Sylvia's channel and she has it working. Hister, did you email me? Y'all, I don't see her email. Sparks1565 is my email. Sparks1565 at gmail.com. Okay, there we go. Kim C had a question. Kim C, I don't see questions, y'all, because remember I'm on a different screen and I have something in front of me, so I don't. So what's her question?
She said, no one has been able to direct me to the answer of why YSL Mondo is not part of this RICO indictment.
I can't tell you. I don't know. That's a question I can't even answer. I don't know. I really don't know. I don't know. He just recently was arrested too.
Well, she sure was rubbing on his back.
I don't know.
Okay, check your email.
So she said, check my email. I don't see anything in my email. Somebody sent something in my email. I don't see anything.
Oh, no, she says she can read off stream.
No, I'm not going to be able to hold the string because I'm helping my mother. That's why I'm asking somebody.
Let's roll.
Okay, go ahead.
Come on, we got the people waiting.
Because I have to get. I'm helping my mother right now, y'all. She needs help.
All right, State of Georgia versus Jeffrey Williams. State's response to defendant's motion to disqualify lead prosecutors. Ooh, wee. The state of Georgia, by and through Fonnie T. Willis, District Attorney of the Atlanta Judicial Circuit, hereby responds in opposition to defendant Jeffrey Williams' motion to disqualify lead prosecutors, Chief Deputy District Attorney Adrian Love, CDDA Love, and Deputy District Attorney Simone Hilton, DDA, filed on July 10, 2024, and on July 18, 2024. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, defendant cites no facts and no law that authorizes honorable court to disqualify either CDDA Love or DDA Hilton. Accordingly, the state respectfully moves this honorable court to deny defendant's motion to disqualify the lead prosecutors in support of the response in opposition to defendant's motion to disqualify. The state shows this honorable court the following. Where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to defendant, the laws of Georgia and the facts of this case mandate the court's denial of defendant's motion to disqualify. In support of his motions to disqualify the lead prosecutors, defendant asserts that Lawyer Love and Lawyer Hilton have made themselves critical witnesses in this case. When CDDA Love engaged in text messages with a witness, and when CDDA Love and DDA Hilton participated in a hearing in chambers with the witness and his lawyer regarding contempt proceedings against the witness. Defendant cites no legal authority in support of his position. Defendant, however, bears the heavy burden of proving the disqualification of the lead prosecutors in the case is warranted. See Lewis v. State. Instructing that it is the burden of the party seeking to disqualify counsel to prove the extraordinary remedy of disqualification is warranted. Defendant does not even attempt to meet this burden. Instead, he rests his pleadings on legally and factually unsupported assertions. A, the hearing in chambers was proper. Defendant asserts without support that CDDA Love and DDA Hilton are disqualified as prosecutors in this case because they attended a hearing in chambers that he believes himself entitled to have attended. Defendant argues that the lead prosecutors in attendance at the hearing are disqualified under Georgia Rule of Professional Conduct 3.7a from further prosecuting the case because defendants now needs to examine them about the hearing and what took place. Defendant's argument is not grounded in law. The hearing in chambers was about an ongoing contempt proceeding against a witness who, upon motion of the state, has been compelled to testify but refused to do so. See transcript of June 10, 2024, ex parte hearing in chambers. The hearing was proper. See King v. State. Ruling where King had complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify in King's trial and confirming the use and derogative use immunity that would apply to the compelled testimony. The hearing appears to not have been a part of the proceedings against King. The Georgia Supreme Court pointedly recognized in King 27-3 Georgia at 264 to 265 under circumstances closely resembling those here, that while King might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order compelling the witness to testify in King's trial, or that would suggest that King's rights were the subject matter under consideration. See Williams v. State. On the contrary, the trial court was obliged to consider whether the testimony was necessary to the public interest, a matter which King had no standing to address. OCGA 2498A. Any alleged bias on the witness's part was the proper subject of cross-examination, not grounds for denying the state's request for the order. See Mosher v. State. Holding that the credibility of a witness ordered to testify under OCGA 24928 is a jury question, emphasis added. Likewise, in Allen v. State, the Georgia Court of Appeals cited King in support of its holding that a defendant had no standing to contest the grant of immunity to a witness under both King and Allen. The June 10, 2024 in-chambers hearing was proper, and defendant had no standing to contest the hearing or to participate in it. CID. Surely defendant does not expect that a proper hearing, which he had no standing to contest or to participate in, now somehow provides defendant the right to disqualification of the lead prosecutors who took part in the hearing. Such a position makes no sense. B, disqualification of the prosecutors would constitute an abuse of this honorable court's discretion where other sources of evidence about what happened at the hearing are available to defendant and to alleviate any need of defendant for either prosecutor's testimony. Even if the hearing had not been proper, an even bigger hurdle barring disqualification of the prosecutors is the availability to defendant of other sources of evidence of what happened during the hearing. With some exceptions, Rule 3.7A of the Rules of Professional Conduct of the State Bar of Georgia provides that A, lawyers should not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. However, the party moving for disqualification of a lawyer under Rule 3.7 has the burden of showing that the lawyer is likely to be a necessary witness by demonstrating that the lawyer's testimony is relevant to disputed material questions of facts and that there is no other evidence available to prove those facts. Well, Clow versus Rigolo, defendant cannot meet the burden. The hearing in chambers was taken down by the court reporter and transcribed. All parties now have the transcript of the hearing in chambers. The transcript clearly identifies those who were present, and that includes sheriff deputies, investigators from the district attorney's office, the witness currently on the stand, and the witness's attorney. Indeed, defendant will get to cross-examine the witness at issue himself. The practice of trials attorneys testifying is not approved by the courts except where made necessary by the circumstances of the case. Timberlake versus State. The advocate as a witness poses innumerable threats to the integrity and reliability of the judicial process. Castell versus Kemp. Courts have properly refused to permit a prosecutor to be called as a defense witness unless there is a compelling need. Citations and punctuation omitted. United States versus Robertson. Trial courts are generally held to have discretion on whether to allow a party to call opposing counsel as a witness on the view that attempting to call opposing counsel to establish some fact that can be readily proved in a different manner should be discouraged. Louisiana versus Tusino. Goodwin versus State, emphasis added, there is no compelling need for the lead prosecutors to testify, especially given that there are ample other sources of information to establish what occurred at the hearing in chambers. CID. Disqualification of Prosecutor Love based on the exchange of text messages with a witness also would constitute abuse of this honorable court's discretion, where other sources of evidence about the text messages are available to defendant and alleviate any need by defendant of CDDA Love's testimony. With ample sources of evidence about the text messages being available to defendant, most notably the witness herself, whom defendant already has examined at trial. Defendant asserts that the text messages also require his examination of CDDA Love. The law contradicts defendant's assertions, scoffers say, noting that speculation as to the content of the opposing counsel's testimony could not support a disqualification order. The Georgia Court of Appeals held in Scoffers State at 640 to 642 that the trial court abused its discretion when it disqualified trial counsel on the basis that the trial counsel's testimony was necessary, where the victim made a statement in his presence, but the statement had also been overheard by both the victim's mother and by trial counsel's assistant, who could testify to the circumstances surrounding the child's statement. Although that Scoff Court agreed with the trial court's concern that the trial counsel's testimony would be relevant to the jury for determining weight and credibility to assign the child's videotape recantation, and possibly the preferred method. Scoff court ultimately concluded that trial's counsel testimony was not necessary to prove any fact related to the video or the circumstances surrounding the video. In Clow versus Regula, this court explained that such speculation as to the content of the opposing counsel's testimony could not support a disqualification order. Otherwise, any party could successfully move to disqualify an opposing attorney by simply averring that the opposing attorney might possess information that it is damaging to the attorney-client's case, and therefore that the attorney is likely to be necessary witness in the moving party's case. To approve of such tactic would be opening the door to blatant misuse of a rule that already has great potential for abuse, emphasis added. Defendant proffers no information he seeks to gain from CDDA Love that he cannot quite readily get, has already forgotten from another source. Disqualification of the lead prosecutor under these circumstances would constitute an abuse of this honorable court's discretion. D. Defendant's reference to the formal trial judge has no bearing on defendant's motion to disqualify. Although it is not necessary for the present motion, Williams asserts that he wants to call as a witness the chief judge who recently presided over the trial. The state submits the chief judge is not a necessary witness for the same reason the lead prosecutors are not a necessary witnesses. Moreover, while at no point did the chief judge comment on the evidence before this jury, it appears defendant's primary purpose in calling the chief judge was to ask him to do just that. Although defendant has not requested permission to do that yet, the state submits the court should deny such a request when and if it is made. There is no evidence to authorize disqualification of the lead prosecutors under the two only generally recognized grounds for disqualification of a prosecutor in Georgia: conflict of interest and forensic misconduct, and defendant does not even perpetrate to request relief on these grounds. Defendant does not allege, nor does there exist evidence in this case suggesting that either prosecutor in this case should be disqualified under the two only generally recognized grounds for disqualification of a prosecutor in Georgia. One, an actual conflict of interest exists, or two, a prosecutor has engaged in forensic misconduct. Reed v. State, citing Williams v. State. In McGlenn v. State, the Georgia Courts of Appeals recognized that a trial court considering a defendant's motion to disqualify an elected district attorney or her staff based on alleged misconduct must hold those who allege such misconduct to a high standard of proof, i.d. emphasis added. Even assuming for the sake of argument that the allegations set forth in defendant's motion were true, those allegations fail to meet the high standard required to disqualify two lead prosecutors from an ongoing and well-advanced criminal case in the middle of trial. The extraordinary relief defendant Williams seeks is simply unwarranted, and his motion should be denied without any further proceedings. Conclusion. For the reasons stated above, it will be egregious abuse of this honorable court's discretion to disqualify CDDA Love and DDA Hilton based solely on the diminious assertions advanced in defendant's motion, especially where there is no evidence or any ground authorizing either prosecutor's disqualification. This court should not abuse its discretion by disqualifying the prosecutors, especially where the June 10, 2024 hearing about what defendant and necessary complaints was proper, and there are no available to defendant other sources of the information about what he claims to need to examine CDDA Love and DDA Hilton at trial. Defendant's efforts to forestall the conclusion of the longest trial in Georgia's history by seeking to disqualify the lead prosecutors should be immediately stopped. This honorable court should deny defendant's motion to disqualify the lead prosecutors in this case on the pleadings alone. Respectfully submitted this 26th day of July 2024, Bonnie T. Willis.
I guess they must have heard us because they didn't put capital letters deny.
No, but a couple things in bold on there, but what's crazy is if you go up to the beginning where they put what the qualifications would be to meet that, that is actually met. So everything that was highlighted on there has already been met.
Yeah.
But do you find, okay, so maybe this how I look at it, I'm kind of curious how chat looks at it, but do you find it a little bit intimidating that this didn't come from Love, it came from Bonnie?
But she has to, somebody else had to do it because against Love and Hilton.
But she responded to those in other responses though. So how
But
could
they
she?
weren't directly about her before. This is directly about Hilton and Love. So they could not respond. It has to be somebody else to respond to that.
So they're only getting that proper word because of Judge Krause. So, you know, this new judge needs to debunk that, because nowhere on seeing if someone is going to testify or giving them immunity, all that extra conversation and given wrong legal information and saying we can hold you indefinitely, that's not what the content is. This is a mess. Just a mess.
Somebody said Love could have responded. Not really, because it's against them.
It doesn't matter. I think that was more of a tactic Love definitely could have responded to it was just a motion. And all the other motions have stated what they have felt that ADA Love has done wrong, what Hilton has done wrong, and they have responded. This is not the first time they have been named, not the second time, not the third time, and they have responded every time. This right here is a tactic. She didn't want to, she wanted it to come from there so that way the judge sees, but the judge shouldn't even take that even into consideration because no motions has been coming from her, number one, and she picked and chose who she was gonna throw in there. And then the last sentence under the conclusion, where it says this honorable court should deny defendant's motion to disqualify the lead prosecutors in this case on the pleadings alone. So that's saying you should deny it because of who they're saying to throw off. Because that is a chief deputy district attorney and another lead district attorney, for that title alone, you should dismiss that. And that's improper. That's saying because of their title, you should be dismissing this, not because of their actions. But I mean, let's be for real.
Thank you, Jazz.
Fonnie ain't been there. She's been wrapped up in her own RICO.
Yeah, but y'all got to see the previous motions. Bonnie's name has been on those.
I don't know. I just feel like it's an intimidation tactic. That's my opinion, and that's the opinions don't go nowhere. I just don't feel like we should be seeing anything from her at this point. Love is a big girl.
Thank you, Black Butterfly. That's a recusal.
Okay, so I just pulled it up for Georgia. It says, yes, the district attorney can respond to any recusal motion if it pertains to them. Only a judge cannot.
Where'd you pull that up from?
I went under Georgia law.
What's the law number on that one?
I'm gonna send it to you.
No, Bianca, she won't be there. Yep, she sure did, Ashley. I was reading that the other day. She sure did. Hipster, that was that you that said that it's me? Because I don't recognize the name. Okay, so I guess they're still going to be submitting some more motions. All right, let me put the link in here for. That was you? Okay. Thank you. I got it. They have until 11:59. Yep, Melanie, they do. Hey, Hipster.
Hey,
Yeah, I did not know it was you. I saw somebody say it's me, so I didn't think. And because then I got another email from somebody else. I'm like, okay, which one is her?
mine's from hippieista.yahoo.com.
Let me see. Okay, I got it. The next one that comes down, I'll give it to you.
Okay.
We're still waiting. We still got until 11:59, I guess.
Oh, wow.
Yeah, because there's nothing
There
else
was
on.
it.
They haven't spoken about any of the bond motions. They haven't said anything about the bond motion, so I
Well,
don't know
what
what
is
they're.
this? What is this new transcript that everybody's talking about in chat?
I saw it's the same transcript. I don't know what new one they're talking about.
Okay. Just asking.
No, I mean, I was reading it. It looks like the same one.
Mm.
Sylvia, I did get a few messages too stating that there is other pieces added that weren't in the original.
There are a lot of transcripts that I have that I already did before. I have transcript that I have before.
I just do not see how Whitaker, that's her name, right, is going to get up to speed at any point. I mean, and how you can tell a whole jury, just forget everything you've heard. Pretend it didn't exist. I loved Weinstein's, if you say don't think about a big-eared elephant, all you're going to think about is Dumbo. I just thought that was the fact that he put that in a legal document is just wonderful.
Weinstein has very good wordplay like steel.
Yes, he does. And he also knows a ton of quotations, because in something that was read earlier, he quoted Churchill and Truman and even Fawny herself, which I thought was hysterical. I thought, you go. That's the way you do, is put their words back to them.
Well, I think citing that case about the child takes no precedence. The reason why that would be in question because it was a child. So of course they're going, there's going to be issues around that. So using that case law is very weak because there's no minor here giving testimony.
True.
And the amount or the type of questioning that prosecution has to go through with a child on the stand is totally opposite of what is happening here. So to state that case law, if everybody looks it up on their own and reads it, pertains nothing to this.
Mm.
Has to do with the child and the testimony, the credibility, and how they had to question that child.
Mm-hmm.
It has nothing to do with this.
Although most of these people were minors when all of this occurred, or some of them were. I mean, think about Little Rod. he has basically been in prison his entire life. And he's what, 19, 20? Did he turn 20?
Not sure.
I mean, that's just, I know he's been in since he was 13. And that's just not right.
So how do you see this case concluding?
I hope to God in a mistrial. And if it's not in a mistrial, they're just going to spend a whole bunch of more money for it to be overturned in appeal.
True.
And I don't know, fortunately, I live in Texas. It's just as bad as Georgia, I guess, from what I can tell from all of this. Texas is not an exemplary state anymore. But if I were spending my tax dollars in Georgia, I'd be so pissed. I want my money back.
Yeah. It's a lot of dollars to bring this amount forward.
I mean, somebody somewhere said that they thought they were allotted $5 million for this trial. They spent $5 million before they even got the jury set.
Well, yeah, because that took almost a year.
Yep.
Because they had to put together the case that they had already did a report on and said they did years of an investigation.
Which, I don't agree with that either. Because the state was in no way ready to go.
They may have been with the other one that left. Sound like he did the majority of the work.
The other DA.
Correct.
Okay.
Jerry.
I wish we could have seen what he would have done.
Well, the same. The evidence is the evidence.
Yeah, but the way you present the evidence is different depending on the person presenting.
It's very hard to present when you don't have much.
Well, that's true. You have a great point. That is a great point.
You know, if you have limited information, really doesn't matter how long you can, no matter who presents it, you can only stretch that to a certain point where you don't have anything else.
That's true.
It's like arguing with the wall.
Yeah.
It don't move.
Yep.
We have seen 100 witnesses. They've impeached everyone.
And we still haven't seen a RICO.
Well, I think we have the three that are involved. The three DAs, that's more than one, an act of committing a certain act. They're in tandem with this.
Okay, I will absolutely agree with you. Amen on that one.
Everybody's definition of a thug is different.
That's true.
It's just, it bears down to not, you don't want to attack their personal character. Nobody personally knows them, right? Nobody knows them outside of that courtroom. But you can only judge them from what you see on how they're presenting and how they are acting as professionals. And we've seen a lot of unprofessionalism. We've seen a lot of ethical issues. We have seen lying caught on numerous times. We've seen lying on the stand. We've seen where the DA has injected herself during the line of questioning.
Right.
It's just a lot of things are wrong. If you write down a whole list, you're not going to get through one page. So I best, basically it's time to clean it up and move on, because there are true people sitting in that jail that need to be in them courtrooms dealing with their case.
And
All these courtrooms are being held up for 4 big cases that they brought forward at the same time. They bit off more than they can chew, and they don't have the staffing to take part in what they brought forward.
well, and they don't even, it's staffing, it's court space, it's, you put this many people in a courtroom, you can't even hardly get all of the defendants and their attorneys in there, much less, other people who are supposed to be able to be there, like the family, the victims. I'm surprised they haven't made the jury go over to the overflow room.
I mean, they're the true victims here, those jurors.
The jurors, oh, absolutely. And if I were them, I just don't know that I could come back. I'm just sorry. I don't know what they could do to me, put me in jail, hold me in contempt. I just don't know. But, I think I would have to slip on the steps of the courtroom as I walked up or something. I don't know.
It's just really sad, because it's this is real life. It's real life people at stake. And then you think of the mental toll it takes on somebody to sit behind them walls and have to be on lockdown 23/1.
And Stillwell has been stabbed twice. I mean, that's not right.
You said what? I'm sorry, I didn't hear.
Stillwell has been stabbed twice, right? Hasn't he been shanked twice while he's been in there? I know once, but I thought twice.
Sylvia?
He's been stabbed multiple times.
Okay.
Not 2 occasions, but multiple times. Could you please stop putting other people's content creators' name in the chat? Please do not put other content creator name in the chat. Thank you.
Hello, who is our new person up here? Oh, she went away. I hope I didn't scare her away.
Says, yep, you can tell from the prosecution's body language that they didn't like her. They are death nervous. Ashley, are you talking about Steele's attorney? Are you referring to when his attorney walked in the courtroom? It changed the whole mood. It just goes to show that there's obviously favor, right? There's favor. You got 2 well-known rappers on the same, plateau out there, successful. One is able to make bond. One is able to be endorsed by the district attorney's office. They're able to conceal his slate, drop 12 of 13 charges. And then on the other hand, because it's a opposing party that you don't no longer care for, then none of y'all get nothing. You get nothing, and we're seeking the max. It's clear to everybody in the public.
Well, and not only that, and I'm not saying that money should get you off, okay? But we have seen nothing that ties Jeffrey to any of this. And wouldn't it be better for Atlanta for him to be out there making a ton of money? So he has to pay taxes. He buys stuff in Atlanta. He buys properties for his relatives. Wouldn't it be better for the Atlanta economy for him to be not sitting in this courtroom and not sitting in jail and making money? and getting more fame. I mean,
Well, the first thing I would do if I were him after all this mess, I'd take all my money out of there. I take all my money out of there and I'm going to put it into a state that appreciates what I do give back to the community. And I'm not going to put any more money to that community.
I understand that, and I would do the same. I would think the same way, but I just think he has too many people, too many relatives there, and he's too family oriented for him to do something like that. I think he's going to be there, I guess is what I'm saying.
After this, I'd take the whole crew out. I'd take the whole crew out of there. It's just how it's operating, or until the seats in office change. And that's just what it is.
And I don't see that happening. The seats of office changing. So this is just a mess. It's a mess. I'm glad I don't live there. I'm glad it's not, I think probably ultimately all of our tax dollars are going towards this, no matter where we live. But I would just hate to be there and know that my city is getting such a bad name.
Yeah. I just try to be respectful on Miss Sylvia's platform. How I really feel, I can't say it on here. Maybe one day I'll just go no hold borrow mine and just let it all loose. I want to respect her platform and how she runs it, but I'll go on mine and act crazy. I don't care.
You go, girl. That'd be great. Sylvia, what's your mama cooking?
Pork.
Well, that sounds good.
It's called griot. As y'all can tell, I'm eating, right? Sorry. And John.
It's nice that you can have your mother cook for you. My mother's 90, and I cook for her.
Oh.
And I'm proud to do it. So I'm not asking for sympathy or anything. I'm proud to do it, but life changes when you get older.
Trust me, I know.
Miss Sylvia, Khalees said, and famous Sylvia and crew dropping jewels. Kiki, enjoy, auntie. Eban Suck, laugh out loud, said, are you sharing, Miss Sylvia?
That's why I'm hiding.
Okay, two minds. Okay, so look, wait, let me clarify something for unpopular opinion. She's so funny. She said, when I said I'd take them all out, meaning businesses, houses, taking all the family out, not taking nobody else out. I'm talking about taking businesses and his loved ones out of that state. So let me put an emphasis on that. So that part ain't taken. Well, she said take them all out. No. I mean, take his businesses, everything that he has endorsed. Take it out. Take it out. And take your family out, because the money that you're putting in, the respect and love you're not getting back, and only so many people is gonna put in so much. And if you're out to get somebody that much, why would you expect them to put any of their dollars in to the very community that is tearing them down?
And I guess that was my point. That was my exact point, is unless you absolutely have a picture of Thug holding a gun and shooting someone up close and personal, why would you be doing this? Because they absolutely have no evidence like that, or at least they haven't shown it to us yet.
Well, the evidence is on the table. I mean, it's all out there. That's what they got. That they got what they got. Everybody that they're bringing into this is already doing time, and everybody sitting in there is just an extension to a personal promise that was given to an opposing side. But like I said, I just be careful what I say on here to respect Miss Sylvia's platform. This is her platform, and I, don't want to get wild on there. So if somebody want to get wild and have something crazy to say, send it to me. I'll put it on. I'll do one live and no hold bar. Let it all out.
Shell, you did win. But we don't know yet. Hold on, Shell.
Shell says she won that bet.
Yeah, because
She
she should
said
ask
she,
for it.
she said she didn't ask for an extension, so she won the bet.
She sure did.
But Sylvia, you're still getting lunch, so
I hope that's dinner at 8:00. It says, imagine if
That's Tuesday. That's Tuesday, ma'am.
You said Tuesday what?
That's for Tuesday, not today.
No, I know. Tuesday.
No, I was telling
Okay.
Miss Mike over here.
And y'all, this is a funny. The other day when I was watching, and you know, I'm in Houston, so y'all are an hour ahead. And you said something about it being 4:30, and I thought, oh Lord, I got to go put dinner on. And then I realized, no, it's only 3:30.
I'm going off of Sylvia's time.
But I almost had dinner going an hour early.
What time is your time?
It's 7:13 right now. It's
Okay,
8:13 where you're at.
Yeah. Mm-hmm.
I never knew that. I didn't know where the time changed that direction. We were in Atlanta, and we went to a church there, and we thought we were early, and we were an hour late for church. But that's okay. Still a good meeting.
Okay, Renee's device keeps saying not connected. She's been trying to connect in here, and we're having issues.
So Ashley says, my dad was a warden for 20 years, and I told him about this case. He thinks their constitutional rights have been violated.
I have no doubt, but I don't know who we would get it in front of to go along with that.
Says, because in the DA mind, Thug is already doing life and thrown away. They don't care about ATL as much as they want the fame for destroying a beloved artist.
Yep.
Well, I just say, just imagine if somebody does become president.
Lord help us all.
That very county that came for him.
I practice O Canada on a daily basis.
John, you're back, John. What about the murder victims and drugs peddled to victims? Come up and talk about it, John.
Like my avatar here says, and the reason why this means so much to me is my birthday is August 26th. And I am so proud that I was born on Women's Suffrage Day. But this is my PSA. Everybody go out and vote. Do not stay home. My granny always said, you cannot give your opinion or criticize if you don't vote. And I swear I will always be able to give my opinion and criticize. That's my PSA for the night.
That's right. Use immunity.
All right, now we're just waiting. I think they have a couple of more. I know they have the motions for the bonds. They haven't responded to those.
Well, Miss Sylvia, I'll come back if you need me to read. I'm going to drop off now.
Truthfully told,
I want some more people to come up here and give their opinions. I like hearing other people's opinions and thoughts. I learned from that. And I love you two ladies, and y'all be blessed.
you too. Have a great night. Thank you. Truth be told, I lost my other page. So I had to put this one on. People play too much. Danny said, did they respond to Harvey motion? I don't believe so. I don't remember reading that one. Sylvia, did we cover Harvey's motion?
No.
I didn't think so. Shell, no, nobody responded about those bonds. Life Free said, y'all get y'all popcorn ready for Tuesday. Yes, Miss Sylvia got to go in a 3-piece suit. Sylvia, I'm looking at the different ex partes. I see that the little hyphens are added in a lot more.
It's the same one. I read it. It's the same. It's 54 pages. It's the same.
I was just going line for line.
It's the same one.
Pamela, Miss Sylvia does not want the names in the chat.
Whose name? They put another content creator name in the chat again?
Mm-hmm.
No content creator names in the chat, guys. This will avoid any kind of conflict. Please do not put their name in the chat. Thank you.
Unpopular opinion, that is so true. It says, all right now, y'all know we have to be a few minutes early to be on time. Glanville got us so used to slacking when he was on the bench. I promise you, I used to go take a whole nap and it still wouldn't be back up.
Yeah, anyone can come, Tyler. All right, guys. There's nothing on. You said what's wrong, Betty? I'm just tired. I'm tired, mentally drained. Hey.
Miss Betty, we are on a diet. We are having no sugar, no flour, no wheat. Really unpopular opinion. I used to literally take a nap and it would still be the emblem on the wall. I was gonna go Wednesday, but I don't know. How many of y'all think it's gonna be a lot of comfort? Or how many comfort breaks y'all think they're gonna get from 8:45 to 6 p.m.? Cora says 2. Angie 2. Pamela 2. 2 comfort breaks and a lunch. Whoever got a weak bladder better go invest in Depends before Tuesday.
I'm back, guys. Gemini, you feeling better?
You digging me 4 and a lunch. Oh, sure is. Cali time. Oh, I hate it when I was out in Cali because you're so off on time from everybody else.
BG, thank you. Okay.
It's, remember when Steele said in court once, I need to go wash my hands.
Come to Florida?
Sonia, because I'm laying in my bed.
Did anything drop? No, not recently. Yeah, she's gonna be there on time, Kiki. She's gonna be there way on time. And I warned y'all about her. Thank you, Kay.
She seemed like she get in at 7 a.m.
She's an early bird.
I don't think has there ever been court past 5?
Yeah. Yeah. Where you been?
I'm talking about with Glanville.
Where you been?
I don't know. It always seemed like 3:30 was a natural stopping point.
No. We've been in there one time till 11 o'clock.
Hmm. BG said, what time does the court open though?
8:30. Yeah, we were there till 11 o'clock one night. Mm-hmm.
Was that during jury selection?
One jury selection and one regular one since the court started. They were arguing over some motions at the end. They had let the jury go home at 5, I think. And we stayed really 10:30 or 10:45 is the time we got out of there. And this was like, I think, if I'm not mistaken, around April, I think.
I was trying to remember back, but it just seemed like it was a lot of natural stopping points before 5 p.m.
That was the latter part. It's been like that, but around May, April, February, March, he was in there a long time.
So like at our courthouse to get through security, it take like 35 minutes. So 15 minutes to get through security and in that courtroom.
But you got 3 entrances.
Oh, that's the difference right there.
3 different entrances.
See, they changed ours. It's one way in and one way out. And then you got to go through the x-ray machine, and your purse or whatever you got in your pockets has to go on the conveyor to go through the x-ray machine.
Yeah.
It'd be a whole lot.
My sinuses is bothering me.
I think it's the air. I know we got a bad storm coming. It's dark outside already.
Let me see if it's a storm coming here.
Yeah, I can see it. The clouds are real ugly. It says, y'all ever have a party?
Sanya, I'm getting messages about you. Sanya, you being rude in the chat? They said they were being rude. I'll pass you on I-20. So you do, Tyler?
Yeah, there's a few. There's a few, Sylvia. Your mods are cleaning up.
Guys, please be nice in the chat. Because you always say I'm rude and nasty. So I'm trying to change my attitude. So please be nice in the chat. Please be nice in the chat. Uh-oh, another motion just came in. Hold on. What's wrong with my thing? My thing is not, it's acting up.
Nick, Nick Foley too, if that does happen, you know there's something in the water. KK, yeah, there's definitely trolls.
Let's see. I don't see anything. Somebody said it was something. It's nothing.
You said it's nothing?
I don't see anything. No, nothing. Nothing, nothing, nothing.
What do we have left that's outstanding? Harvey's? Yeah, Nick, we read that letter yesterday. Yesterday or the day before, we read the letter of recommendation from the DA's office. Shell, yeah, we read it yesterday. I think you had just got off when that was read.
Sorry about that. That was Dallas calling me. Sylvia, are there any other trials you would be covering? Yeah, BJ, there's a couple of them. BG, I'm sorry. BG, yeah, there's a couple of other ones that I'll be covering. And we're covering Boosie's situation. Myself and Dom. Dom is my boots on the ground with that one.
Dr. T, thank you.
Oh, to mind. One mic. I'm tired. Do you think we're gonna get something else today?
I'm trying to look at my paper right here to see what's outstanding that we missed that hasn't been responded to. And the only thing, yeah,
bonds haven't been responded to.
I don't think that's going to be touched. That's my opinion. I don't think that one's going to be touched because there was no right to do that. I think that's going to stay where it's at.
I don't think so. Let me tell you the reason why, because what I told you earlier, with the case with that guy, that was just recently done in April 2024. And that guy was convicted in 2022.
See, that's Patty. Yes, that is. My other channel's gone, Patty. I don't even want to talk about it. I got one subscriber. Oh, I had to make another one. It's brand new. The other one I had from 2014.
Black
Miss
butterfly.
Sylvia, you have done an awesome day and served us well. Get some rest. You're appreciated. They're
Thank you.
sending a lot of love, a lot of positivity. It's really changed up the whole chat. Very nice messages.
Black butterfly. Thank you, sweetheart.
There's several of Dr. T. There's a few. We better because state is weak sauce. Dr. T, it was some bad mouths I do not like. Dr. T, they know. Yeah, we definitely don't want to push no negativity or anybody else. It's a hard job that Miss Sylvia does. It really is a hard job. If you guys would ever try and put yourself in front of the camera and try to bring that, it's not as easy as it looks. It takes a lot of time, dedication, and you have to create banners. You got to watch your content. You got to be careful what you say. That's why I just keep mine open to go crazy on. Miss Sylvia, can you tell Woody we love him and to keep his head up? You got a super chat.
Will do.
Love me some Miss Sylvia for 5. Say thank you.
Thank you, Black butterfly. Shell, it was yesterday. His birthday was yesterday. What happened with Woody? He hasn't know. He's having a party today. A birthday party today.
Yes, Shell, it's his birthday. He is grown today. Coco said motions are falling out of everywhere.
Bless, I'm waiting for the stuff to drop. That's why I'm still here. I'm waiting for stuff to drop.
While everyone's waiting for the next motion, if y'all could hit that like button for Miss Sylvia, that would be great. She tired and starved.
I'm not starved. I ate.
Well, I feel like I'm starved. This no sugar, no. I just feel no to everything. That's how I feel at this point. Everything is on the no list. I tried so hard today. I can't complain. It's for my health. But man, it's not easy.
Miss Betty, I'm not sad. I'm not sad. I can't hide nothing from you, huh, Miss Betty? I can't hide nothing from you.
It's on your face today, Sylvia.
I can't hide nothing from her.
It is, but I mean, y'all really think about it. You have other folks that are tearing her down, and then you have folks that come in the chat and still try to tear it down. It gets draining. It gets draining.
It's a rainy night in Georgia. Is it raining? I don't think it's raining here yet.
You got a storm coming your way, right?
I don't know yet. Let me see. I don't know. I don't know yet. Let's see.
KJ said they better leave Auntie alone. Lavelle said, how is it possible 495 likes and 414 people in there?
There was more people earlier.
Yeah, people are coming and going. I see that a lot went out and a lot just came back in. So 80 had dropped off and 94 picked back up. So you're going to see it waver. Miss Sylvia, should we share the news?
What's the news? Hold on, I'm trying to be nosy right now, y'all.
Okay, will you be nosy and see if you want to share it? Unpopular opinion said it's not raining where I am, but it's probably on the way. What coast are you on? Shell, no smoke with Dr. T, Shell. No smoke. That's one of her mods. Jerome Street said, love you guys. And famous following you on TikTok. You got a TikTok follow. That's right, Coco. Guys, support Miss Sylvia and spread love. We want change. Please remember the purpose. Jerome, she definitely appreciates that. She's having a rough day today. But she got some great things coming for you guys. Mrs. Shanti, so what's going on? Is today the last day to submit motions? Yes, today is the deadline. No more can be submitted after today. Green eggs, no ham, you off of work. That's right, Coco. I'm surprised nobody responded to Harvey's motion. LaBelle tried calling her phone. She had to run downstairs. KJ, they don't want no smoke with Harvey. Definitely not. Not if a whole brew is named after him. Auntie Christy, she went downstairs. She'll be right back. You're welcome.
I'm back, y'all. Sorry. I had to open up the door for Dally.
Yeah, I told him you have to run down.
I had to open the door. Thank you, Tony, for the cash app.
KJ, would that be something? To be an intern with Steel? That would be a great thing.
Kokomo is one.
Yeah. Who would not want an attorney that's willing to go down for your client because you know he's being violated? Say, well, if you're going to lock me up, put me with him. Anybody's going to respect that. He didn't want to miss 1 minute off that case.
All right, can we find out if we got any more? Nothing else has come in, y'all.
I'm upset nobody's responding to Harvey. He had a good one.
Nothing else has come through.
KJ, I did write one. Right to the commission. The way they all swarmed in there for him was something. They should really do a movie behind this trial. Black Butterfly says Harvey, aka Finish Them. You ain't never lied. Sylvia, check your phone. LaVale had messaged you. Yeah, they should, KJ. They really should.
I don't see Lavelle message.
I put on there twice to check the phone.
Okay.
PayPal. Evan Sucks says they don't want no smoke with Harvey.
Lavelle's funny. Thank you, Lavelle. Thank you for the PayPal.
Tracy said the defense should have been filed bar complaints on Love with all the unprofessional lying she do. Probably when it's all done, you're probably going to see those things.
Hmm. Hey, 444 smile. Yeah, we're gonna. It's 9 o'clock almost. Are we waiting for?
Okay, so it's just the bond motions that are left hanging out there. Harvey's is left hanging out there. And one of Steele's and Weinstein's was never responded to. He had two.
We've got Kendrick's Weinstein mistrial. You have Stillwell's mistrial, fair trial. You have reconsideration for Copeland. You have recuse. Okay, we did the recusal one. The only one he addressed was he hasn't addressed Stillwell's.
Oh, what about Matthews?
He hasn't done Matthew. That's a bond. That's a bond.
Yeah. That's why I say I think they're just staying away from the bond in total.
But he still hasn't done the mistrial for the fair trial with Stillwell.
Raymond says, I'm an attorney in North Carolina, and the state needs to float down to reality and give up on this embarrassment. Much better off in the long run. Free Thug, free YSL.
Aw, Edward, thank you. Edward gave me a command. Get some rest right now.
To the best, my NY friend.
Thank you, Jerome.
Look,
Appreciate it.
that was huge, Jerome.
Lavelle said, if you're tired, why don't you break and get some? If you find something, break. I just suggest don't wear yourself out. It's not this, y'all. It's other things. I just got other things going on. It's not this. Trust me. This is just like my getaway right now.
Mr. 444, I believe there is enough circumstantial evidence to move forward, but too many rights violated to continue. Marley said, just leave the chat to us. Just turn your screen black. We'll behave.
You sure, Marley? You'll behave?
Marley, it's been cutting up in here, so
Marley, you're gonna look. I'm gonna leave you in charge, Marley. If I come back and it's bad, people being bad, I'm gonna get you.
Shell said Marley lies.
Nona, thank you for the cash app. Nona, thank you for the cash app. Hey, look who came to visit me, y'all. Look who came to visit me. Look who came to visit me. Look who came to visit me, y'all. Look. Who came to say hello to me? Kobe came to say hello to me. Kobe came to show me some love. Right, Kobe? Kobe come to show me some love. Kobe.
I got mine jumping on me right now, but he's an XL bully. Ain't nobody picking him up.
Kobe's like, he says, I come to talk to you, Grammy. I come to talk to you, Grammy. This dog very sensitive, y'all. Look how easy tempered he is right now.
He needs water.
He knows I need a hug. Right, Kobe? Kobe said, I know, Grammy. You need a hug.
Don't they sense it?
Kobe do.
Mm-hmm.
All right. See you later. See you later. You gone? You gone? He gone, y'all. He's gone.
We got a XL bully looking for a girlfriend.
Shell.
Take him here.
So you behaving in there? That's my emotional support dog.
Bring him to court.
Bring him to court.
Bring him to court.
He came to give me a hug. Down.
Cavell says, I have a girl bully XL. She's not ready though. Cavell, he's ready to go.
Hey.
He's that I forget what's the name of that rare one. He looks like he's camouflage.
He came to give you a hug. Kobe, what you eating? Y'all want to see Dallas's plate?
It's not pretty.
She said her plate's not pretty. Show it to them. Yeah, I saw her plate.
What?
Oh yeah. Just all wrong for that.
Oh, Dallas?
Yes, all wrong for that.
She eating.
You told me to show them.
Why act like I almost smelt it?
Dallas, you got the onion and the sauce?
It's good.
I guess because I ate it too early, huh?
And I put the sauce you made, the gravy.
Oh, she made some gravy?
I think I can't give Kobe this fat.
I told you again. There's nothing in it. Kobe said, give me some.
It's so fat.
Yeah, said, give it to her. Give me some.
Cavell, I don't know the name of it. It's something with the M. What is it called, Cavell? I say camouflage because I have a hard time finding them at night.
Like that, right?
Unpopular opinion, okay? Putting that whole plate in the camera like that.
Dallas, they talking about you again.
You told me to do it.
And then And then on top of it, her mama got other people starving out here. So yeah, then show us that good old plate.
Y'all
I
can eat.
swear,
Y'all can eat this.
There's no sugar
It's
flour.
there's no sugar, flour, wheat in that.
man, everything I've looked at say sugar,
No,
wheat, flour, everything I done tried. Oh yes, Cavell, that's the name. That's the name right there. Lord have mercy. Yeah, that's the name of them.
yes, green egg, no ham. She made some grill. She sure did. Dallas had some in her place. She made some Jean rice too.
And he got them bright sky blue eyes. Cavell, you know I don't know the name of it. I just call him camouflage. But his name is Suge.
You hear him smacking.
You smacking Kobe? Kobe over here eating up a storm, y'all. That's enough for you, boy. Look at him. He's smacking.
He ain't on no diet.
Kobe. It's good, ain't it? Look at him licking his tongue. Licking his
Cavell, they say they worth more money. I don't know. No, we didn't crop his ears. I was afraid to crop his ears. They say it hurt.
Kobe. Kobe, you have a good time with that food over there. Y'all, do you think we're gonna get anything else tonight?
Well, I hope somebody respond to the rest of those and not just leave them out there for, well, they can. No, his ears are regular. I don't like that chopped up look. They say it's mean. His ears are normal, but his muscle strength ain't no joke.
Oh yeah, I'm about to get off this live because y'all getting boring. People dropping off. Y'all boring me.
You got over 300 people in here, and you feed the dog a good old plate of food.
I'm not feeding the dog. That's Dallas feeding the dog.
Dallas feeding her and her child right now.
Uh-huh. Yes, Pamela, they do still have to respond. They still have to respond.
Wait, which one? Because
Huh?
I thought that they don't have to, but they should.
Oh no. I'm saying they don't have to. Huh? See, you say you leaving? Uh-uh.
Ain't nobody gonna respond to Harvey. Don't nobody want Harvey to be put no motions up on them. Oh, they said somebody got a fever. Somebody's sick. Justice Matter said the court clerks are gone home for the weekend. The rest of the stuff that comes in late will probably processed and stamped on Monday. But we got one late, Justice Matters. We got one late, 7:30. Oh, Geminique, feel better. You got a couple days to rest till Tuesday. Black Butterfly says, I love how Harvey says Mr. Nichols. You said true and through. Get some rest, Gemini. We see you tomorrow. Yeah, Edward, you're right about that. People don't give Mr. Harvey enough credit all those times. He objected and requested the severance and the standing. Shook it down. You're too big. You can't go on my lap. Mm-mm. Don't start that mess. Get down. They need to. Who wasn't a member, Cavell? Aw, somebody gifted 5 memberships. Love Nona Creations gifted 5 memberships. Thank you so much, Love Nona Creations. Miss Sylvia will see it when she comes back. All these bond motions that are left hanging out there, that's crazy. It's not one. Edward, how would you rate the motions filed from Steele? I know the title says something positive, but 10 being solid. How far from solid are his motions? I think Steele and Adams always bring the heat. I just want to give a shout out to Adams because I know that we always say Steele, 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 but Adams is a force to be reckoned with. They a great team. I love how he cross-examines. He goes real fast. I think both of them are very solid. They make a great team. And Max don't care. He just wants the reports. I love to see Mr. Matthews and his son paired up on this together. That's monumental. That's a great history point for the both of them. I'm glad they're doing it together as father and son. I love to see that. So salute to Mr. Matthews and his son. Miss Fat said missed everything last night. How many of y'all think the bond motions are just not going to be replied to? At Jason, this one week going forward.
It's raining.
Yes, it's cutting up over here bad.
It just started raining, y'all.
My windows just started shaking about 2 minutes ago with the wind.
Is the party over, AJ? The party? We're waiting.
Sylvia, they said that the other motions probably ain't going to be stamped till Monday because ain't nobody at that courthouse processing them at 9:14.
They come automatically into the system.
Oh, I don't know what that person was. Let me see.
They come automatically into the system. Now the ones that come at 11 o'clock, those will probably come on Monday.
Justice Matters said, no, it's considered still on time. It may just have been no one's able to process it. Staff are gone, no penalty for anybody. So that wouldn't apply here because it's automatically dropped in there.
Astrology Mind said they will reply. Who is Law Malcolm? Who's drinking? I'm not drinking. Well, as you said, drinking water. And Marley said, poor performance from the judge. Hey, Antonio, you see you got your color over here, right, Antonio?
Man, that's hilarious. Edward said Birdman is going to be so confused on the stand with Miss Love asking questions. So he's not testifying.
Well, won't do.
Oh, yeah. All right, guys, it seemed like nothing else is going to come through tonight. I am going to end this live.
Kim C, I'm not sure who everybody's saying that, but we don't know where that's coming from because they said it's still the exact same transcript. So I'm not sure. I did see it on another place too, but I don't know. Edward, I think both have both been.
Consequences, they're not going to take into consideration if they don't get it in. So her thing will have to have like the date, tonight's date on it. And if not, they'll just not consider it.
Okay, so
Someone did 10 membership while I was gone? Somebody get membership when I was gone?
yep, Nona Creations gifted several people
Thank you, Nona.
memberships.
Thank you, Nona. Appreciate you. Thank you, Nona.
So if anything else drops, are you going to come back on to cover tonight or are you going to cover in the morning?
No, I'll cover it tonight.
She gifted 10 memberships. She did 5 and then did another 5.
Thank you, Nona. Thank you, Miss J, for the super chat. Thank you, Black Butterfly, again for the super chat. I'm going up to everybody that gave something.
And Miller, yes. Had that thing leaking. I don't think they're going to respond to the bond because what can you actually say? What can you actually say? The judge that we got went with whatever we asked for.
All right, good people. Thank you, Two Minds and the Mic. I'm about to take my butt off this live. Thank you so much for your reading. Appreciate it.
Just call me on if something drops tonight. I'm going to lay it down for a minute because I can't eat. It's after 9, so I got to wait till tomorrow.
Have a good one. Good night, everybody.
Y'all have a blessed one. Have a great night.
KJ, good night. All right, let's go. Good night. May the Lord watch between me and thee while we're absent one from another. Amen. I'm going to go to the other channel and have some fun over there since it's raining outside. Talk to you guys later. Bye.
you.